Good evening, everybody, and welcome to another edition to the Medical Negligence series with Advocate Denise Chamisa. Advocate Denise completed his BSOC, BCom Honors, LLB, and LLM at the University of Cape Town, and having done his undergraduate degrees at UWC. He is currently the Director of DEC Legal and Associates, as well as the Director of a Student Legal Services. And for tonight, Advocate Denise shall discuss a key question. What does it mean when you sign an informed consent or an indemnity form? This is a daunting question for so many of us. So, Advocate, what does it mean? What is medical consent or informed consent?
Okay, thank you for asking such a question. In the medical field, medical consent is quite an essential principle, be it ethical or be it legal. Consent, the literal meaning of consent could be permission to do something. But in the context of medical field, then we're looking at the consent. For instance, let me give reference to informed consent. A health practitioner or a healthcare provider ought to or need to educate the patient regarding the risk, regarding the benefits, regarding any alternatives that could be available with reference to medical intervention, medical procedure, or medical treatment. So when we're looking at informed consent or consent in general, a patient should be given information to be in a position to make an informed decision regarding whether there are any benefits, regarding whether there are any risk, regarding whether there are any alternatives, and to appreciate such risk and benefits before making any decision. So in this case, like I alluded earlier on, informed consent is actually derived from an ethical or it has got a legal and ethical obligation for medical practitioners. That is the definition I can give to the meaning of medical consent. However, if I am to add on, with your permission, there are different types of consent in the healthcare. We are just looking in the context of healthcare. For instance, there is implied consent. For instance, like what is happening currently, people are being vaccinated. If I go to the vaccination center and I remove without asking anyone, I'm there presently, then I'm actually pulling my sleeve up for me to be vaccinated. That is implied consent. The conduct indicates that I am giving permission for them to vaccinate me. And the other example I can give is express consent. This can be in writing. For instance, you put it in writing and you sign, that is express. Everyone can actually see it, it's written and it's signed. The other type I can refer to is the one I was referring to as informed consent. Informed consent now, as I alluded to the definition, it requires every patient who appears within the medical facilities to be informed, to be educated regarding the risk, the benefits, or alternatives with reference to medical intervention procedures or medical treatment itself. The last one I can refer to is whereby it's referred to as unanimous consent. Unanimous consent is whereby there is no objection. Let's say there are more parties, there are 5, 6, 7 parties who requires attention, but there is no consent to that effect. So basically, all are giving consent. That is, I think, among the types of consent in the healthcare.
Thank you, counsel. Thank you so much for that clear definition. So I think now for me, the question then is in terms of standard disclosure that's to be expected in terms of the doctor providing you with information.
Come again with the question.
The question for me here is in terms of disclosure, to what extent does a doctor have to disclose the difficulty of an operation or a procedure? So if there's an anomaly that's maybe a 0.1% could potentially happen if you have that operation. If the doctor or the medical board failed to inform you, would that affect your informed consent in any way?
Yeah, what I may allude to, in South Africa, informed consent is quite dominant, in the sense that informed consent has been part of South African law, in that the patient must be informed. The patient must be informed at all material times regarding medical treatments, be it diagnostic, be it therapeutic, regardless of the risk, regardless of the extent of damage that it makes. They must be informed. For one to be informed, one has to make an informed decision. For one to have that information, one will be knowledgeable, one will be able to exercise a informed decision, making decision from an informed perspective. So in this case, we're looking at, for instance, in South Africa, informed consent is part of our law. Informed consent, as I alluded, we are referring to sufficient information. Your question is, to what extent the patient ought to be given sufficient information to make an informed decision. The patient in this case actually ought to understand the information. It's not only giving information. The patient ought to understand the information. If it means for the information to be conveyed in a language the patient understands, that ought to be done. Because at the end of the day, it's about the patient understanding what the doctor is saying, the implication, the benefits, or if there is any alternative to that effect. So for instance, if I am to give you an example, for instance, the person that is in prison, or for instance, you can refer to children. A person in prison has got limited rights, for instance, but children also have got limited rights to some extent. For instance, if I give an example of, in terms of Child Act, a child that is 14 years may independently consent to medical treatment regardless of the existence of the parents or the guardian. So in this case, the law also gives certain children of certain age the ability to consent to medical treatment. A person that is 18, for instance, is able to consent to any operation. So if we are looking at to what extent can a doctor provide that information, as I alluded earlier on, it is in the context of ethical principle, it is in the context of legal principles to give patients information they can understand, information if they ask, because it's not about giving information. The patient can also ask for clarity, can all ask so they can understand what is it that they're going to be able to conduct themselves in terms of the operation. Or in other words, can the doctor or medical practitioner refrain or hold information from the patient, such as defined in the context of ethical principles. Such would be unethical if the doctor would withhold information. It's necessary to provide information that is sufficient so that the patient be able to appreciate the procedure they are undertaking.
So then, counsel, it's really, if I'm understanding you correctly, it speaks to patient autonomy and the right to know. So the doctor must then provide all the knowledge to that particular patient regarding a procedure.
Yes, I agree. My answer is in the affirmative, in the sense that informed consent relates to the person's rights. The fact that you are providing information, you are asking for permission, which means you are acknowledging that that person has got, for instance, certain constitutional rights which cannot be breached. In this case, there is a right to human dignity and body autonomy. So the reason for permission, you want to protect the patient's rights before undertaking any procedure or before actually pursuing any medical procedure or treatment whatsoever it is.
And then you did state that there's various types of consents. In South Africa, what type of consent is the most common?
In South Africa, informed consent is the one that is dominant in our law. I think even case law, I think if we are to refer to Stauffenberg versus Elliott of 1912, such a principle had been actually in use if we had to go back in time. Informed consent is part of our law, whereby it goes back to the principles in medical law, whereby saying, can a patient be given the power to decide whether to undertake a certain procedure, can a person be empowered with information that is sufficient to make an informed decision? And that information that is given also need to be accurate, so that the patient will be able to make a decision. But if the information is not accurate, then basically that's when we come into issues of negligence, the issues of misconduct, because even the HPCSA has got guidelines regarding good practice in healthcare, which resonate around issues of informed consent. So in South Africa, informed consent is a dominant principle, and it has been applied in South Africa for a long time, because it has got certain elements that we need to be aware of. There are certain people that may not have the ability to consent. For instance, a mentally challenged person has got limited capacity in the sense that they can't make informed decisions. So that one has to be assisted with a guardian. And also in such situation, there are elements of informed consent. For instance, if I may give you a few examples, a patient must be capable of consenting. That's one thing. That's one of the key elements in South Africa. The other element that I can refer to, consent must be voluntary without restraint or condition. The last but not least, consent must not be contra bonimo, in the sense that we have got the Constitution that has got a Bill of Rights. For instance, I think what is happening, I can give you an example regarding the COVID-19. The reason why some people are deciding not to be vaccinated and others being vaccinated is based on this principle of the contra bonimo, whereby it's like they have their rights, which they're saying we are human beings. We are vulnerable to the disease. However, I have the right to a religion. I have the right to certain opinion or scientific opinion, which empowers me not to undertake such a process or medical procedure. So at the end of the day, such are the key elements, but the Constitution becomes the binding factor in terms of how informed consent ought to be conducted or practiced in medical field.
Just to come in there, Counsel, with regards to the example that you gave with COVID-19, it seems as though many employers are actually strongly prompting their employees to receive a vaccination. How would this affect their informed consent? Could vaccination be compulsory? In the context of the Constitution, it's pretty much difficult for that to be done, because remember, every right, there is no right that is absolute, in the sense that rights ought to be weighed against each other. And we have also Section 36, which is a limitation section in terms of rights. So if we are to look at any rights in South Africa, they ought to pass that limitation factor. So in this case, we're looking at COVID-19 that has caused havoc around the world. But in the workplace, most of the companies, they want to implement such a policy. First and foremost, they need to have COVID-19 policy and guidelines within the workplace. Without such a policy, which forms part of the company policy, they can't regulate, which means there is no regulation for misconduct if the employee decides not to. However, there are certain employees that may not wish to be vaccinated. They have got a constitutional right. They have got the protection of the Constitution. In any given society, like South Africa, which has got, I think, an advanced constitution, which is quite of qualitative nature, this means that the employer ought to treat two different categories: those who are vaccinated and those who are not vaccinated. Those who are vaccinated, yes, they are complying with the company policy. And those who are not vaccinated, now they need to sign certain forms. For instance, if it is a religious reason for their defense that we're not going to be vaccinated because of such. So if it is an opinion based on scientific opinion, then basically they can say we're not being vaccinated because of my certain beliefs. I can't do that. So at the end of the day, the company will need to balance these two categories. Those who are not vaccinated or fully vaccinated, they need to undergo maybe weekly but periodical testing. They need to be treated differently, or they can work in isolation. There are different ways of managing such employees because there is a policy.
but they are not complying with that policy. But does not mean that they cease to be employees because of such. That's why the employer has got an obligation to take alternative measures to look at such a group and to enforce their constitutional rights.
Very, very interesting. I think many employees will find this podcast extremely beneficial. So if we're coming then to another area, looking at what the implications are of the exemption clause to patients.
An exemption clause, mostly I think people that have been to hospital visiting or otherwise, they normally sign contracts without even reading through. Some of the prints are small, but they still sign. So in this situation, you're dealing with a contract, where you're dealing with an agreement. So in a contract, it is a contractual term. It's like if you had to talk about exemption clause, it is a contractual term or a term in a contract in which a hospital attempts to protect itself. So the hospital draft the agreement, the hospital draft the contract in attempt to protect itself from being sued by the patient in the event of negligence. So the purpose of it is just for protection purposes. Who is being protected? The one who is drafting naturally. And for what purposes? To prevent litigation or to be held liable in the event, because these are unforeseeable situations when one is admitted or one is undertaken to do an operation, such unforeseeable, whether it's going to be successful or not, you can't tell. So those are the issues they want to prevent themselves from. So in this case, we are looking at the patient's right will be limited. Because the patient's right is limited because a patient can appear for present him or herself to the hospital for medical treatment or procedure, but the patient's right to sue is limited. As a result, the agreement is there to exclude liability for the medical healthcare or the medical practitioners. Such is a challenge. One may say it's a challenge in the sense that the standard is not two-sided. It's a unilateral contract. One party decide to draft the agreement. The other party is a recipient without any input to that agreement. So some say it's an unbalanced agreement. But there is a case that I may want to refer to whereby the question whether a patient becomes vulnerable because of a weaker bargaining position, can that be sustainable? The Afrox Healthcare BK versus Tridom 2002 Supreme Court of Appeal decided otherwise, that in the case whereby there is no evidence of an equal bargaining position, then basically the drafter of the agreement is protected, which means the clause will be upheld. So there is need for evidence to suggest that, no, I was, or the patient was in an unequal bargaining position. If there is no such evidence, then basically they may not be able to claim or to fight such a clause, which means the hospital or the medical healthcare will be protected in such events. This complicates the legal position of the patient, if I am to add, because the standard contract with an exemption clause, it says take it or leave it. That's what it says. And you are there in need of assistance. So you don't have time to negotiate because life is something that you can negotiate with. So you rather sign because the standard contract says this is what we are offering. It's either you sign. If you don't sign, then you can't be offered that medical assistance.
No, that's extremely comprehensive, counsel. I think everyone is going to appreciate this podcast. Another point that I'd like to make is whether you think the way we understand informed consent or maybe even implied consent is affected by the digital era that we're moving into at the moment. So does digitization or even the use of artificial intelligence to a certain degree, does it affect the way we explain what informed consent is or the way informed consent is really perceived by the patient? Is there an effect from the digital era with regards to informed consent or consent as a whole?
Yeah, I think there are we are living in a different world, and most of the entities or medical healthcare facilities or medical practitioners, they tend to, it's like adjusting to the changing circumstances, in the sense that instead of paperwork, now we're using electronic papers. But for instance, you may have to sign electronically, but the content will not change. What is imperative, what is important, what is necessary is for the patient to be informed. If it's going to be digital way of communication, still there is a need for sufficient information to be provided to the patient regarding the risk, regarding the benefits, regarding alternatives that may be available for the patient to exercise, regarding any medical procedure whatsoever or treatment. So at the end of the day, the content or the information will not be waived because of digitalization. But it's like the platform under which it is being presented may differ, but still the question remains, are patient informed? Are patient informed well to make an informed decision? Are they provided sufficient information? When they ask for more information or clarity or question, are they given such information? So that obligation, remember when I alluded to ethical obligation and legal obligation for medical practitioner or medical healthcare, that obligation cannot be waived willy-nilly. It is an essential obligation on the part of medical practitioner, regardless whether it is digitalized or not. The obligation cannot be waived.
Thank you so much for that, counsel. So just to summarize then, in terms of what we've looked at for today, we've looked at what medical consent or informed consent is. We've looked at what the various types of consent in the healthcare sector are. We've looked at the common type of consent that's used in South Africa. And very interesting to find today, looking at what the implications were for the exemption clause to patients, and then looking at how digitization has potentially affected informed consent. I think you've provided us this evening with such jewels of wisdom and nuggets and take-home messages that everyone can really sit and listen to better understand the document that they're signing when they enter into the hospital or before they undertake a procedure. So these modern times are extremely important for one to understand before really attaching your signature to anything. So
certainly.
If I could say then that the modern medical advances have really helped millions of people to live longer, healthier lives. And we owe a lot of the medical advancements and improvements to this decade in terms of research that's been done, as well as human capital, innovation, and then better understanding the legal side to the medical field. So thank you so much, counsel, for actually taking time to explain these important questions and answers for us. Is there anything else that you would like to address or closing remarks from your side?
Yeah. In conclusion, I can just add that notwithstanding the last aspect I was discussing, the exemption clause, we have also the Consumer Protection Act. If we are to refer to a particular provision, that's Section 48, that can be of essence in assisting patients in the context of the exemption clause, in the sense that the Act, in this case, the particular provision prohibits unfair and unreasonable and unjust conduct, or conduct that has got terms that tends to be of disadvantage to the patients. So in other words, it is imperative for the medical practitioners to alert patients regarding the existence of such exemption clause. I think in conclusion, I think I can conclude by such a statement.
Thank you very much, counsel, for joining us tonight. Have a wonderful evening further.
Okay, thank you very much.